if you break the law, do you lose your right to actually shape the laws? It's a pretty profound philosophical question, right? I mean, does committing a crime totally sever your social contract with society to the point where you literally forfeit your voice in how that society is governed?
Welcome to The Explainer. Today, we're diving deep into the source material surrounding a massive landmark case from the 2004 South African Constitutional Court that wrestled with this exact dilemma. It's a fascinating legal thriller that pitted the fundamental human right to vote against the state's interest in upholding the rule of law, protecting its finite resources, and denouncing crime. And let me tell you, this one went right down to the wire. Here's our agenda for today's Explainer. We'll be covering the context and the clock, the constitutional clash, the state's defense, the global perspective, the final verdict, and finally, fixing the voter's role. All right, let's jump right in.
Section 1, the context and the clock. We are racing to Election Day.
The urgency surrounding this case was absolutely immense. Picture this. In late November 2003, the government passes an amendment to the Electoral Act. By December 17th, boom, it's in force. Just 6 days later, an organization called NICRO, along with 2 prisoners at Pollsmoor Prison, sues the government. Because of various legal delays, the case actually leapfrogs the lower courts and goes straight to the Constitutional Court in late February 2004. So why the frantic rush? Well, National Election Day was already set for April 14, 2004. The highest court in the land literally had just a few weeks to decide who actually gets to vote.
So what exactly did this new law do? The Electoral Laws Amendment Act of 2003 targeted a very specific group. It deprived convicted prisoners serving sentences without the option of a fine of the right to register and vote while in prison. Now here's the nuance. If you were just awaiting trial or if you were locked up simply because you couldn't scrape together the cash to pay a fine, you could still vote. But if a judge sentenced you directly to prison time with no fine option available, your right to vote was suspended for your entire sentence. And that right there is exactly what sparked the lawsuit.
Section 2. The constitutional clash. Rights versus reality. To really grasp the gravity of taking away the vote, we have to look at what the vote actually means, especially in South Africa's post-apartheid context. In a previous ruling, Justice Sachs delivered this incredibly powerful sentiment. He stated, "The vote of each and every citizen is a badge of dignity and of personhood." Quite literally, it says that everybody counts. So you see, the right to vote isn't just some procedural mechanism, it's deeply, deeply tied to human dignity. But in the South African Constitution, no right is entirely absolute. Rights can be limited, but only under very strict conditions. To test those specific conditions, the court uses the Section 36 limitation analysis. Think of it as a constitutional formula. If the government wants to limit a right, the burden of proof is totally on them to show that the limitation is reasonable and justifiable in an open and democratic society. They have to run through 5 steps. Weigh the nature of the right. Look at the importance of the limitation's purpose. Examine the exact nature and extent of the restriction. See if the limitation actually achieves its purpose. And finally, ask if there was a less restrictive way to do it. Now, the government openly conceded that the new law did limit the right to vote, so the entire case hinged on whether they could justify it using these 5 steps. Section 3. The state's defense. Justifying the ban.
The state's defense was really built on this harsh contrast. Up against the undisputed constitutional rights of the prisoners stood the very cold, very hard realities of state resources. The Director General of Home Affairs argued that setting up mobile voting stations inside prisons and guaranteeing the security of those special votes places a massive financial and logistical strain on the Electoral Commission. At the end of the day, state resources are finite.
But the state's argument actually went way deeper than just money and logistics. First, they argued it was fundamentally unfair to divert scarce resources to set up special voting stations for criminals, especially when law-abiding citizens, like folks who can't travel because of work or illness, might struggle to get to the polls themselves. Second, they emphasized the absolute need to protect the integrity and security of the voting process. But the third and fourth points are really the crucial policy arguments here. In a country dealing with high crime rates, the government argued it was vital to firmly denounce crime and definitely not appear soft on criminals. They wanted to send a clear message that constitutional rights are tied to civic duties. Essentially, if you break the law, you temporarily lose the privilege of participating in the democratic process.
Moving on to Section 4, the global perspective. Let's look at how others handle it.
Now, the real takeaway from the source material here is that there is absolutely zero global consensus. Democracies worldwide are completely fractured on this issue.
In Canada, for example, their Supreme Court struck down blanket bans, ruling that voting is totally essential to democratic legitimacy. Meanwhile, in Europe, it's a huge mixed bag. You've got countries like Denmark and Sweden with no bans at all, while others tie disenfranchisement proportionally to the specific type of crime or the length of the sentence. And then over in the United States, almost every state disenfranchises prisoners convicted of felonies, sometimes even long after they're released. So the global standard? Well, it's that there really is no standard.
This complete lack of global consensus heavily influenced the dissenting judges in this case, who completely agreed with the government stance. Justice Madala delivered a very passionate dissent, making the case that temporarily suspending the vote is a totally valid tool for social condemnation. As he put it, you cannot reward a responsibility and criminal conduct by affording a person who has no respect for the law the right and responsibility of voting. He basically argued that unique South African problems, namely rampant crime, require uniquely South African solutions.
Justice Ngobo also dissented, agreeing that disenfranchisement serves a highly legitimate constitutional purpose. He stated, "This limited limitation of the right to vote sends an unmistakable message that the duties and responsibilities of a citizen also include an obligation to respect the rights of others." So, for the dissenting judges, this temporary loss of the vote wasn't just arbitrary, it was a proportional, reasonable response to the breach of the social contract.
Section 5. The final verdict. The court's decision.
But ultimately, the majority of the Constitutional Court ruled against the government, declaring the disenfranchisement unconstitutional. And it really all came down to two things: evidence and precision. First off, regarding those logistics and costs we talked about, the state simply failed to provide empirical data. They claimed it was too expensive, sure, but they offered no actual numbers or proof that it was logistically impossible to let these prisoners vote. This was especially glaring since they were already setting up mobile stations for unsentenced prisoners. Furthermore, the law was a blanket exclusion. It totally failed to tailor the limitation to the severity of the crime. Whether you committed a minor transgression with a short sentence or a major violent crime, the penalty was exactly the same. Because of this lack of hard evidence and lack of precise tailoring, the government's case completely failed the Section 36 proportionality test.
To underline their philosophy, the majority actually relied heavily on a famous Canadian case known as Suffrage, pulling this striking quote: "A government that restricts the franchise to a select portion of citizens is a government that weakens its ability to function as the legitimate representative of the excluded citizens." The majority's conclusion was clear. Yes, denouncing crime is absolutely a valid government objective, but you cannot simply write fundamental rights out of the Constitution to achieve it without incredibly precise, evidence-based justification. And our final section, number 6, fixing the voter's roll, the logistical miracle.
Remember that ticking clock? The national election was literally weeks away. In fact, by the time this judgment was handed down on March 3rd, the national voters' roll had already been legally closed and certified. The state had argued it was flat out impossible to add the prisoners at this late stage, but the court essentially looked at them and said, "Make it possible." They ordered an absolute logistical miracle. They declared the disenfranchising clauses invalid, ordered the Electoral Commission to completely bypass the legally closed voters' roll, physically visit the prisons to register eligible voters by April 9th, and prepare a supplementary roll before the April 14th election. They literally forced the entire state apparatus to adapt in order to protect this single right.
Which brings us to the end of our explainer and leaves us with this final, incredibly provocative question. Should democracy guarantee the vote to everyone, regardless of their actions? Or is the franchise fundamentally a privilege, one that is entirely dependent on maintaining your civic responsibility? The South African Constitutional Court ruled that rights remain rights even behind bars, unless the state can overwhelmingly prove they absolutely must be taken away. But as those strong dissenting opinions showed us, this is a debate that strikes at the very core of what it actually means to be a citizen. Thank you so much for joining me for this deep dive into the source material. Never stop asking the big questions.